Good afternoon. My name is John Duffy. I'm the founder of Zen Wealth Consultant Services, helping you to be the peaceful center of your finances. Let's take a look. Today's webinar is about estate planning basics, and it starts off basic, but by the time we get to the end of it, we'll have an example that's starting to delve into the complicated. So when we get there, bear with me. But in the meantime, let's deal with some of the real common issues, concerns that people have, stuff you know you need to do, but you haven't done it yet. You've been putting it off because you just don't want to get to it. Let's talk about why it's important to get to it. Okay, so what is an estate plan? An estate plan is basically just a plan. It's a map. It's a way for you to dictate your wishes, whether they be in life or in death. And it's an opportunity for you to have your assets and your estate taken care of the way that you want to take care of the people that you want to. Now, who needs an estate plan? It's not a bad idea for anybody to have an estate plan. It's not something for the wealthy and the uber wealthy or anything like that. It doesn't have to be a complicated or expensive process. But if you have a complicated estate, it will be. You just have more things to have to deal with. You're going to have more time, for your estate planning attorney to work through the plan with you. It's just going to take some effort. But one of the things that's really good, even if you're not a millionaire, is if you were to pass away unexpectedly, your estate is going to go through intestacy rules and probate and all sorts of things. It's going to get divided up in ways that you may not have intended, and taking care of the planning portion will allow that to happen. If you don't do that, your family members might be, kind of ticked off, kind of confused at why it worked out this way, why, the way that they're being supported might not be the way that you had ever intended. So especially if your spouse is not comfortable with financial, matters at the investing, the portfolio, all of those sorts of things. First of all, the two of you, have a sense of your finances. I will strongly urge you to work on those together. And if one or the other spouse needs some financial education, talk to an advisor. That's one of the things that I really enjoy doing is, for somebody who has little to no experience, let's start at the basics and work our way up. It's really important, though, for people to have some level of financial literacy. In fact, I'm looking to, with a friend of mine, put together a curriculum to get into high schools to help them with some financial literacy. If you have minor children, you don't want to have the court decide who's the guardian. You want to be able to pick a guardian yourself that you would want to have for your kids. If for some reason, either if you're a single parent and something were to happen to you, or you and your spouse were to get in a car accident or a plane crash, or all these things that you hope never happens, usually doesn't, but every now and then, it does. Nice problem to have. If your net worth exceeds $11,700,000, that's the transfer tax exclusion amount for 2021. This is the highest it's ever been. And that's just for you. If you are married, your transfer tax exclusion amount is twice that. So 23,400,000. Again, nice problem to have, but people do have that issue. They have estates larger than that. You've got to make the planning for it. This is one of those cases where it's going to be more complicated. If you own property in more than one state, you have an estate plan. It's going to just kind of take so much time for that to get unwound through probate. And if your financial privacy is a concern, this is a large concern for many wealthy families, multi-generational wealth families, families who built up a company They just don't want necessarily all the details shared with the world if the world was so inclined to go looking for them. And if you own a business, you want to be able to dictate your succession plan rather than have people guessing at it or decide it's just not worth it and we're going to sell it. All right, so basic estate planning concepts. You're planning for incapacity when you can't make the decisions for yourself anymore, or at least for a temporary period of time. One of the more common things to address is healthcare and property management. These are pretty simple, straightforward to deal with. Planning for death is, of course, part of the estate and wills. Wills and probate will kind of dictate who gets to take care of your things for you, who gets things, how they get divided, all of those good details. We'll talk about just a little bit of the tax basics, the gift taxing and all of those fun subjects. Your lifetime gifting that you get to do throughout your life. Life insurance, which plays a big part in especially maybe larger estates, but even the smaller ones. Life insurance, if you have a family, is a real nice way to help offset your excuse me, your loss as maybe the primary breadwinner, or at least a necessary contributor to the family lifestyle assets. Trusts are a part of how you set all of that up, and we'll get into these. So I personally, I know people at this point who one day they woke up and everything was great, and by the time it was night, they weren't the same for the rest of their life. Either a stroke, a heart attack, an accident. You know, these things happen, and ultimately, sooner or later, you are going to die. And you know, you think it's going to be late, but you might as well start planning for it early. If you fail to plan and set your wishes, you know, in filed paperwork with the court system, they're going to have to appoint a guardian for you. This could be your spouse, it could be a sibling, it could be a child of yours. If you haven't had the conversation with that person and they weren't expecting to have to take on this, you know, it's a burden. This is going to be maybe a difficult thing for them. One of the things that will happen is that anytime they want to do something on your behalf, if you have not stated, made your wishes clear that this person is your guardian and has the power of attorney to make decisions for you, every time they need to do something for you, they have to go to the court and request it. And it's just going to be a time sink for them. So don't do that to somebody that you love. And secondly, they're not mind readers. They don't know what you want to do. If you haven't already set up your estate and your wills, you also probably haven't had the conversation with the person that you wanted to be your guardian. They don't know what you're wanting to do. They're going to try their best, but you're putting an awful lot of responsibility on them that they weren't necessarily well prepared for because you didn't do it. So as far as incapacity goes, there are kind of two main areas. There's the healthcare side of it and the property side of it. So there are a couple of simple ways to deal with these. On the healthcare side, you've got your healthcare directives. This is going to include a living will, which will appoint who you want to, you know, make decisions for you. You've got your durable power of attorney that allows somebody specifically to make healthcare decisions on your behalf. The will is going to kind of say what you want to do, and then the durable power of attorney for the healthcare proxy is the one who gets to make those decisions based on what you mapped out for them. If you want to have a do not resuscitate order or a DNR, those are pretty common. None of us want to be a burdensome vegetable and, you know, living in the hospital with no hope of recovery. You need to do that formally. There in California, there is paperwork that the state has to complete for that. You can get medical bracelets or jewelry, necklaces that will specify do not resuscitate, but this is one of the things that you have to do this properly, or it can't be abided by. And on the property management side, one of the easiest ways to get your assets to the people that you care about and wanted to get them to is with joint ownership. That will allow the assets to pass right over to, for instance, your spouse. If you were to pass away, they continue to have all of the same rights and privileges as they did when you were both alive. You also can set somebody up as your durable power of attorney to make, this is separate from healthcare, although it could be the same person, to make financial decisions on your part. I have a friend who has a history of Alzheimer's in his family. So he has designated somebody to be his healthcare power of attorney to kind of make the decision if he is starting to slip and headed towards incapacity. And that person then will have the conversations with the doctor, and they'll come to make a decision. And then he has a separate person who is the kind of the financial power of attorney, because that person just has dealt with money more. The other person has dealt with healthcare more. It's a smart way to put people in charge to look after you. And then living trusts are a pretty simple, straightforward way to specify what you want to do. And because you can have a successor, you can have a co-trustee or a successor trustee, and they will just automatically be granted the power to make the decisions or utilize the property the way that you had and the way that you intended for them. So what happens if you die without any sort of estate plan? There are some of these assets, your 401k, if you've done beneficiaries on all of the assets that you have the ability to put beneficiaries on. So your IRA, whether it's a Roth or a traditional or a rollover, a SEP IRA, your 401k, life insurance policies, all of these things have a beneficiary, and it's something you should be checking throughout your life. You will probably change that. For married couples, it's typical to give your spouse all of your assets. And then there's also what's called a contingent beneficiary, where you can say, if in the event of my passing, my primary beneficiary has also passed, then it goes to the contingent beneficiaries in this way. So have your spouse as your primary and your children as your contingent. If you don't have children, you can maybe go to your estate. But if you have a person that you want to pass it to, name them, not your estate, first. And then after that, all of your property is going to get divided by your state's intestacy laws, which is intestacy is dying without a will. These are, they vary from state to state. And on the next slide, I downloaded for California what they look like, and I'll show you. But what you actually wanted to have happen, it doesn't matter. The state has to divide it the way that the rules say. So it's gonna cause some problems. If you had kids that you wanted to maybe give more consideration to one because they were struggling, younger, you have an older one who's more established, maybe married, has a larger income, whatever it may be, they're just going to get evenly divided. So this is kind of a typical, if you were to pass away, in this example, the husband, these are all kind of male centric slides for the most part, so bear with me. But your spouse would get half of it, and then the other half would be divided amongst children. Again, let's take a look at California specifically. I highlighted a couple of these common scenarios probably, but if you were maybe younger, you had no spouse, no children, no siblings, or if you have gone through your life, decided you didn't want to get married, you didn't want to have kids, all of that stuff, but your parents are still living, they'll get everything. And that's probably about how you would do it anyways, but maybe you had some friends that you wanted to take care of. You won't have that opportunity. If you are married and you have 2 or more children, your spouse is going to get all of your community property. So all the stuff that you earned while you were married goes to your spouse automatically, and then 1/3 of your separate property. So whatever you brought into the marriage, inheritances, gifts, things like that came kind of from outside of the marriage, Your spouse would get a third of that, and then your kids would get 2/3 of that separate property. Um, let's say you'd only been married a short time, and you also received a large inheritance from your parents or something. You won the lottery, whatever it may be, prior to being married. Your kids would get a lot of money, and your spouse would get very little, maybe not enough to sustain them. So these are some of the problems that this can cause. And if you have a spouse and parents, um, but no children, then your spouse is gonna get all the community property, half of the separate property, and your parents will get the half of your separate property. So again, this might not be how you want to divide it, but if you haven't put wills and trusts together, this is how it's going to get divided in California. So kind of have covered what a will, why it's important. One of the things you get to do is you get to name an executor of your estate as well as a guardian for your minor children. Might be the same person, might not. And all of these devices, wills and trusts, you should review them periodically, every couple of years, every time there's a major life change, things like that. You might change your mind on who you want to be the guardian for your children. Maybe it's somebody, a close friend when you're younger, but as you get older, they're getting older too. Maybe you want to, have somebody else, there are just so many considerations. Same with the executor, maybe who you thought would be a good executor at some point, you've changed your mind or they passed away or something like that. So you need to keep reviewing these from time to time. And you don't do this the right way. Do this with an estate planning attorney. You get it, notarized, signed, witnessed, all of that stuff. Don't do the deathbed, scribble something down on a piece of paper. That's not gonna fly. Good luck. So most wills will go through probate, and I think a lot of us have kind of heard that that's a dirty word. You want to avoid probate. It's not necessarily all bad. Once the will is filed with the probate court, there's a process. One of the things is they'll kind of announce to any creditors that this is a period of time where they can collect on debt. If they do it, if those creditors don't respond within a certain amount of time, it's more difficult for them to get to those assets later. And this process, probate, can take several months to a year. So on the plus side, probate is not terribly expensive if you have not an not complex estate. There also is it's court supervised, so although you're dead, you have the peace of mind that what you specified is exactly what's going to happen, to the letter. That protection against creditors that I mentioned, there's kind of a window of time in which they can collect, and outside of that, it's going to be more difficult. On the negative side, it can be really time consuming for complex estates. It can be a multi-year process. And while that's happening, your assets aren't getting renamed or transferred to the people that you wanted them to be transferred to. So for a complex estate, you should take care of the things we'll cover in the next steps. It can also be pretty expensive with a complex estate. You're paying the executor, you're paying administrators, and as the time goes on and on and on, you keep paying them. So that's just going to leave less for your intended beneficiaries. If you have property outside of your home state, you've got to do this ancillary probate. It's just more time and money and complexity. All of this will go on the public record. So again, if you are concerned about your family's privacy, this will become an issue. So how can you avoid probate? Whatever you own, joint ownership with rights of survivorship, that'll pass through without going into probate. Those beneficiary designations for your life insurance and your retirement plans and all of that goes outside of probate. And the other tool, the most common one to do, is use trusts. You've heard of living trusts. You can also make lifetime gifts out of your estate. If it's not still in your estate when you die, it's not there to be going through probate. So now we're going to get into taxes. I know it's a lot of fun. There are a couple different kinds of taxes that come into play here. So you've got a federal gift tax, which is transfers that you make during your lifetime. You've got a maximum amount of that. And then the federal estate tax are transfers that are directed by your will upon your death. And those transfers also have limitations. That's part of the 11,700,000. The two of those combined, you have that exclusion of 11,700,000. If you've given away $10 million of gifts in your lifetime, and this is, charity and your spouse are excluded from this generally. But if you've made 10 million worth of transfers during your lifetime, you're only going to have 1,700,000 more to make after your passing, and anything over that is going to be taxed. And then you've got this generation skipping transfer, GST tax. This is, for instance, grandparents giving to grandchildren. And this is its own separate bucket of exclusion. Let's see. State tax. States may tax also on transfer. And for instance, California is a really low one. It's 0.11%. So not a big deal, but it is going to be part of what happens. So let's take a look at the federal gift tax. This is what you do during your lifetime. You, as the donor, give a gift to a donee. Now, every year you can gift to anybody you want to $15,000 it's been that number for a couple of years, but all of these, including the 11,700,000, those change potentially every year. So what it is right now may or may not be that case when you actually pass away. Something else to consider. So there's your gift tax. Exclusion, this is the largest it's been around ever, and it probably won't persist. So if you happen to die this year with the largest estate, you're dead, but good for you. Otherwise, you're going to have to do probably more planning, and you're going to have to revisit those plans more frequently to deal with whatever, as your estate grows and as the exclusions come down, you're going to have to make some considerations. Now, the federal estate tax is what happens after your death. These transfers to your spouse or a charity are not usually included as counting against that exclusion. Let's see, well, let's go on to the next slide. Since 2011, couples were given portability. So one spouse has that 11,700,000 exclusion, the other spouse does too. If one spouse during their lifetime only used up a portion of theirs, the remaining portion of that 11,700,000 gets to go to their spouse, who also has their own 11,700,000. So for married couples, there's a large exclusion, so that whatever amount below that, up to that, passes on to their beneficiaries tax-free. The generation skipping tax, this is an instance where you or your state, you're giving not to your child, one level below you, but to your grandchild. It's also got its own exemption. The gift and estate taxes that we looked at, those are one combined pot. This is not portable. You can't give your non-used portion to your spouse. Just quickly kind of take a look at how the numbers have changed since 2019. up, 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 this is again probably um, not a sustainable trend. One of the things about, you don't have to wait until you're dead to give gifts to people that you want to see enjoy them. You can do that during your lifetime. And one of the benefits, of course, is you get to see their enjoyment for what you gave them. Hopefully you get to hear a really nice thank you, maybe some flowers, chocolate, I don't know, whatever you want, but you should be taken care of. You get to make that $1,500,000 annually. And if you are giving something like real estate or some asset that is going to appreciate, it gets it out of your estate at the value that it was at the time of the transfer. And whatever further appreciation is not within your estate. So for some people, if they're close to that exclusion rate, and you might just want to get rid of it if you're anticipating appreciation over the next several years of the remainder of your life. One of the things to consider about that, though, is that there's no step up in basis. So if, for instance, parents gifted a house to their child, it was bought for 50,000, it's now worth $1 million. If the child were to sell that, they would have to pay taxes on that gain. When properties passed over after the last spouse passes, there's a step up in basis, so that $50,000 purchase price is moved up to whatever the current value is as of the date of death of the last parent. And so that means that if it's sold relatively soon, there's no tax due on the home. So it's property, a house in particular, is kind of nice to maybe hold on to. Get it out of the estate if you're concerned that it's going to push you over the limit, but it's going to be less of a tax burden on your family if that's more of a consideration if you pass it over after your passing. Okay, so again, this $15,000 you can gift every year. You and your spouse do it. That's a combined $30,000. If you are funding children's, grandchildren's 529 plans, you can give an initial, you can start by giving $75,000. That's 5 years worth of payments into a 529 plan. That doesn't mean you can do that every year, but you can do that initially, and then you can give again in year 6, another $15,000. Your spouse can do that too, so that's a combined $150,000. That's a really nice way to set your kids up or grandkids up for college, but obviously that doesn't apply to many of us. If you're paying a child or grandchild's tuition directly, that's not counted as a gift tax. And the same for medical care. If you're providing directly for somebody's medical care, then that's also excluded. So trusts are a versatile planning tool. They protect you. They allow you to carry out your wishes. They allow you to select your executor, your custodian, all of those good things. And it's a smart thing to take a look at doing. It doesn't take a lot of time. We're going to go into example of trust and life insurance. Then I'm going to kind of go through a complex application of the two of them as a way of passing on more outside of estate taxes, and then we'll wrap up. So a trust is a legal entity that holds property. This is, you create a trust. There's different parties to a trust: the grantor, the trustee, and the beneficiary. And you've got living trusts, and then you've got the testamentary trusts, which are created when you pass. Your will can maybe have a trust get created upon your passing. And then you've got revocable versus irrevocable. So most people, if they have a trust, they have a living trust that is a revocable trust. You can close down that trust at any time, but you also get to dictate and change the way that the assets are disposed of, gifted out, invested, all of that. An irrevocable trust, you have basically put assets into a trust and you really don't have any control over it anymore. Now, life insurance is a big part of estate planning. Not only do you want to probably have some life insurance to cover the cost of the remaining mortgage balance if something were to happen to you, and you are married, you don't want to leave your spouse with a big bill. Again, especially there are considerations if you're the major breadwinner. It can also just provide some liquidity to the estate. If things are going to be tied up for a little while, at least you can get some money into your intended heirs' hands. But the life insurance proceeds, they are tax-free in distribution, but they are included in your estate. So that 11,700,000, if you have the life insurance payments that push that your estate up above that, you're going to have to pay some taxes on it, unless you take a look at one of the following examples. So this is what's called an irrevocable life insurance trust, or an ILIT. Again, this is heading towards the more advanced estate planning, and I'm going to cover that in about 2 months. This, as well as several other more complex trusts that are more about, instead of directing your assets, some of these trusts are used more for estate planning, specifically, tax minimizing strategies, etc. So in this example, we'll kind of go through this more or less quickly. You, the insured, you create an irrevocable trust, and it's key that it's irrevocable. All of this you're going to be doing with a financial, with an estate planning attorney. This is not something you try to do on your own. You name a trustee and beneficiaries. That irrevocable trust then purchases a life insurance policy on your own life, and the trust owns the policy. Irrevocable trust owns the policy of life insurance on your life. You make cash gifts to the trust. Over time that grows. Technically, your beneficiaries could withdraw those gifts, that you're named beneficiaries, but they're part of this plan. You have a long-term plan here for this, so they're going to leave the cash there. That cash is then used to pay the premiums on the life insurance. That's how you fund it. Now, when you pass, this is how it goes. The ILIT receives the proceeds of the life insurance policy. The proceeds are not subject to estate tax. They're in that irrevocable trust. And then the proceeds are distributed to the beneficiaries according to the terms of the trust. They receive the full proceeds free from estate tax. It's a weird little nuanced, seemingly loophole kind of approach, but these have been around. They probably continue to be around. But again, some of these techniques and the ones that we'll learn in the advanced estate planning, at any time the IRS may change, these things might become inaccessible in the future. You always want to be reviewing your estate plans. Set off Alexa. Anyway, so in conclusion, make some plans while you're alive and well. Don't wait until you're old and you think you're closer to passing. Just take care of it now. The sooner you get started, it's easier to make changes, modifications, than it is to start from scratch with a very complex estate. So the sooner you get going, the less time consuming it's going to be, the less expensive it's going to be. It's really not as bad. My wife and I did it for our family. There are a lot of considerations to make as far as executor and guardians and all of this if-then sort of situations, but it's a good exercise. You and your spouse will, I think, appreciate the time working through that together, really getting on the same page. If you're dealing with transfer taxes, estate planning is a good way to deal with those, and you want to make sure that your overall estate plan is current and updated. And like I said, you're going to need to review that with major life changes. And just every now and then over time, the healthcare directive, sometimes the language changes and you want to get that refreshed, all of that good stuff. So that is basic, uh, basic estate planning techniques. Thank you very much for attending. It was a pleasure to have you all. And if you have any questions, feel free to email me. And I will have this posted up on my YouTube channel, which you can access through the website, zenwcs.com. And again, thank you for your time. And I'll see you in about 2 weeks. We're going to be covering retirement planning in 2 weeks. Although we're going to do it on probably Wednesday instead of Thursday. But hope to see you then. Thank you very much. Bye.